Now, Hunter provides no factual basis to support his assertion that all of what we're trying to introduce is outside the scope of the indictment. His motion from Hunter's team is an outdated copy and paste of a motion he's already filed, where Business Associate 1's legal entity would provide management services to real estate properties in Romania, but that was not actually what GP was paying for. While it's a front company, we're going to do real estate services, GP's paying in reality. Now, it's interesting how they just cut this off at the knee. I'm not going to connect it all to Joe Biden. It's like, come on, guys. The only reason Hunter's even in this position is because of Joe Biden. Hunter Biden has a Romania problem. Trial's coming up. This is a fun filing from government prosecutors now that Hunty Poo doesn't have daddy to protect him anymore because they cooed him and threw him out of office. He's in some hot water. This got filed in the Central District Court of California. We got some serious tax charges coming up, but the tax charges, as we've learned about, are just the very tip of the iceberg on Hunter and the Biden crime family's malfeasance. And it's really Democratic malfeasance, right? This is just one cog in a much greater machine of corruption that the Democrats control. And so let's go through this because we're going to learn that government prosecutors are going to come out pretty aggressively in this new case. And so let's explain what this motion is, because this can kind of get procedurally complex, but it's actually quite easy. This is the government prosecutor's response, okay? So they are sending a letter back to the defendants, essentially. Defendants have filed 4 motions. This is the 4th one in limine. This is called a preliminary motion that is going to try to exclude evidence from coming in at trial. So you know when we're in the middle of a trial, people's objection. We try to keep evidence out. Objection. You can't come talk about that. No, that can't come in. This is like a preliminary objection. You're just trying to keep stuff out. So Hunter doesn't want any reference by the government about political influence or corruption. Don't talk about this. And government prosecutors are coming out. They're saying, oh, we're talking about it. So let's go through this. This is the government responding. They say, all right, judge, listen, trial's right around the corner. Hunty Poo has moved to exclude 6 different topics from this entire trial, framing this overall motion, right, bunch of stuff, he says, can't talk about it, as alleged improper political influence or corruption. So in other words, the government is saying Hunter was a bad political influence or he was corrupt. Now, at the beginning, prosecutors write, the government notes that Hunter has accurately represented the position on only one of the 6 topics. Otherwise, he's misinterpreting us. And as explained, Hunter's loser defense team, they did not even seek the government's position on 4 of the topics that they brought up that they're trying to keep out, and they misstated the government's position on another. Now, Hunter provides no factual basis to support his assertion that all of what we're trying to introduce is outside the scope of the indictment. His motion from Hunter's team is an outdated copy and paste of a motion he's already filed. The 2 exhibits that he referenced in the motion are not on the amended exhibit list that the government provided to the defendant before. So in other words, we're not even going to use that stuff before he filed it. Now, absent from Hunter's motion is any reference at all to facts and evidence in the Jenks production that he received before, which is material that the government is saying we're intending to use at trial. In section 2, the government provides a background on some of the evidence that will be admitted, right? This is going to be bad for Hunter because they're like, some bad evidence in there. At trial related to payments that Hunter got from his foreign business dealings, which are relevant. Let's go through them. They say, all right, Your Honor, here's why all this stuff needs to come in against Hunter. As alleged in the original criminal indictment, Hunter was a lawyer, a lobbyist, a consultant. He was a business person, and he generated substantial income to him, including from foreign businesses in foreign countries, as we know. His foreign business dealings, including serving on the board of a Ukrainian industrial conglomerate and a Chinese private equity fund. He also entered into an oral agreement with Business Associate 1. And when Hunter Biden's in this, you don't know what they're talking about. To help a Romanian business person called GP contest bribery charges that GP was facing in Romania. So Hunter comes on as a liaison. He says, my daddy is, vice president or senator. So a Romanian business person facing bribery charges, Hunter can help. Do what? The government anticipates that Business Associate 1, who is the liaison here, this guy was the deal facilitator. It's not going to be the GP, the guy who actually was facing the criminal charges, but the person who helped make this deal is going to come in and testify. He's going to say, this guy and Hunter were in the lobbying and consulting business together, saying that GP was a Romanian businessman who was under criminal investigation in Romania, saying that GP sought to retain this guy and Hunter and another business associate to attempt to influence U.S. government agencies to investigate the Romanian criminal investigation of GP. Wild. Hunter never registered under FARA as a foreign agent and thereby cause an end to the investigation of GP in Romania. Business Associate 1 and the defendant were concerned concerned that lobbying work might cause political ramifications for Hunter's dad. Yeah. Business Associate 1 and the GP, they signed a management services agreement where Business Associate 1's legal entity would provide management services to real estate properties in Romania, but that was not actually what GP was paying for. Wild. It's a front company. We're going to do real estate services. GP's paying. In reality, Business Associate 1 and GP agreed that Business Associate 1 would receive compensation for work by Business Associate 1, Hunter, and number 2 to influence U.S. government agencies, so to cause the U.S. prosecutors investigate Romanian prosecutors to get this guy off the hook. And Business Associate 1 would pass 1/3 of the money to Hunter and 1/3 to business person number 2. It is massive fraud, obviously. Now, since the defendant has failed to provide the court with any facts related to Business Associate 1, Hunter, the government is separately moving to file an exhibit under seal, which is the transcript of this. Wow, that's great. As alleged in the indictment, Business Associate 1's entity received approximately $3.1 million, which was split roughly into thirds between the defendants. Hunter got $1 million from this. As alleged in the indictment, the government will also introduce at trial evidence of Hunter's business dealings with CEFC, a Chinese energy conglomerate, and his compensation for the position of the board of the Ukrainian energy conglomerate. Now, this evidence will not include evidence that Hunter performed lobbying activity in exchange for the compensation. Rather, the evidence will show that Hunter performed almost no work in exchange for the millions of dollars he received from these entities. So, James Comer vindicated. All right. Now here, Hunter is trying to exclude all of this. The first category of evidence that Hunter wants to exclude is any reference to allegations that Biden is acting on behalf of a foreign principal. The government is not referencing allegations. We're actually just going to say he did it. Like, so we're not alleging anything. So, okay, we're just going to say he did it. This guy, they're saying specifically, he's going to come in, he's going to say Hunter got compensation from a foreign principal who's attempting to influence U.S. policy. Like, that's what he's going to say. Not allegations about that you did it. This is clearly relevant evidence. The purpose of the payments that we're going to talk about and the nature of the work are relevant. They establish that Hunter got income when payments were made by a business associate. Moreover, the evidence of what Hunter agreed to do and did do demonstrates Hunter's state of mind and his intent during the tax years that he got charged on this stuff for. It's also evidence that Hunter's actions do not reflect someone with diminished capacity. He attempted to influence U.S. public policy, and he got millions of dollars pursuant to this oral agreement that was concealed as a real estate deal that he was performing for GP, right? So that he doesn't have to register as working for foreign governments or against foreign governments or trying to lobby the U.S. government. Under federal rules of evidence, they say Hunter may exclude evidence if it's too harmful. Okay, this is Rule 403. We talk about it all the time. It's a balancing test. We like to use the teeter-totter example. If it's more harmful than it is helpful, more harmful than helpful, evidence goes out. If it's more helpful than it is harmful, then it comes in. That's the rule. In his second and third categories, Hunter asks the court to exclude allegations that Hunter violated FARA or improperly coordinated with the Obama administration. Now, in their motions, they're talking about different things. Now, the government does not intend to reference allegations that he violated FARA or improperly coordinated with Obama, but we are talking about a structured business relationship. The government will introduce evidence that they did all of this to avoid having to register as foreign agents. That Hunter and his business partners did in fact reach out to government officials. They reached out to the Department of State. It's corruption. That evidence is relevant because it establishes that Hunter received income when he earned the income. What his state of mind was, it was not consistent with someone who's just a drug addict with no capacity. The introduction of that evidence does not mean that government will say that he violated FARA. No, but we have other reasons why we can introduce that. He also wants people to say evidence to be precluded that Hunter did not receive any direct evidence from any income compensation from any foreign state. Now, Hunter has never asked the government for its position on these, but the government can confirm it does not intend to introduce any direct compensation from a foreign state, like Romania was not paying him. So it's moot. We're not even going to try to introduce that. Now, they also want no evidence that Hunter funneled money to his father. The government responded and said, we do not intend to introduce anything about Joe Biden, obviously. So they're not even going to try to introduce it. So as explained above, Hunter did not ask for the government's position. In fact, we're not even trying to talk about things. He's like, you can't talk about this. He's like, oh, that's fine. We're not even going to try to talk about it. But a bunch of other stuff, oh yeah, we are talking about it. Hunter did receive compensation from a foreign principal to attempt and influence U.S. policy and public opinion. It's all relevant. It's not unfairly prejudicial. And so we want you to allow this evidence in. Signed by government prosecutor Derek Hines going in at trial. So it's going to be fun to see. Now, it's interesting how they just cut this off at the knee. I'm not going to connect it all to Joe Biden. It's like, come on, guys. guys. The only reason Hunter's even in this position is because of Joe Biden. He wouldn't have these deals. Who do you think is going to answer his phone calls at the State Department if it's not Daddy Joe over there at the White House? Give me a break. Joe's clearly involved. Now, another good reason why Joe is not going to be their candidate, because this trial would be very bad for them. But an interesting filing. It's very curious how all this stuff is starting to come out. I mean, when Joe was running, we didn't hear any of this. In fact, everybody like Raskin was calling James Comer a liar. It's all true. It's always been true. Everybody in the media lied. They covered it up. Now the prosecutors are now suddenly talking about it because Joe's not running again. Isn't that convenient?